We are back after our lunch break. Commissioner Chosky, do you have additional questions?
Yes, I do. So I'd like to ask a little bit more about staffing at the OCD to review Class 6 rules. Mr. Winkle, I'm assuming these would go to you. How big are other state divisions that have Class 6 primacy or the EPA? How big are their teams that work on this?
So the ones that I do know about and that I can answer here with some confidence, the team in Texas, I believe, is made up of about 10 to 13 folks. They have, I believe, at current about 15 applications that are in. And if you don't mind, I'll punt to Greg for the size of for EPA reviewers.
Okay, thank you.
It's a little hard as the applicant to have precise knowledge, but in my impression, I've worked with one other primacy state that my guess would be 3 to 5 dedicated individuals. And then in the EPA regions, again, you know, just from providing multiple applications and always working with the same individuals, my impression is that those regional offices may also only have like 3 to 5 dedicated permit reviewers and writers.
Okay, thank you. So I noticed that all of OCD's witnesses are outside parties, except for Mr. Winkler. And I was just wondering, it'd be interesting to hear from someone on the Class 6 team who could talk about the actual day-to-day process and their expertise and what they will actually do to review these permits, especially since it seems like a lot of the modeling and very technical review work might be contracted out. Is there a reason why they couldn't testify?
I think it was more of a logistical timing issue. So we just filled the supervisory position, and we didn't feel that they had enough time to come in and look at all the work that we had already done to come in and give any kind of meaningful answers to any questions. Now, they have caught up tremendously all the way yet. You know, I'm not real sure about that.
And I know you gave some of their background yesterday, and I believe you don't need a specialized degree to be a petroleum specialist or a petroleum specialist supervisor. I just was wondering if you could explain some of their educational background.
Sure. Let me find my direct and go over that.
Thank you.
And that is 4. Yeah. Okay. If you guys find it before me, let me know. Okay, right here. Okay, so the current supervisor is led by a geologist, senior geoscientist, excuse me. He also holds a project management professional certificate. I understand that's globally recognized program with accreditation. 25 years of experience in leadership roles in oil and gas activities, mainly in the San Juan Basin. The petroleum specialist that reports to him is a petroleum engineer and comes from a diverse background of regulatory for the Railroad Commission, and also he was a regulatory specialist for a big operator, and he played a lot of different roles, especially in the industry side, but tracking compliance-related issues, auditing on the regulatory side as well. The person that is not listed in my direct testimony that will be starting on September 12th has a PhD in petroleum sciences, published author on multiple papers, and I believe that's the most confident I am without having that in front of me to answer that, but I do know that those to be true.
Okay, thank you. So Do you know what the staff will be looking at as part of these reviews, especially since a lot of the more technical and modeling will be contracted out?
Yeah, so, the good thing about having, rules to go off of, and especially, half of the hard work has been done for us with the implementation manual and the AOR review manuals, site characterization things. It's basically you put into place thresholds, parameters, things that you need to look for. And then, of course, it's on the regulator itself to kind of come up with those internal state-specific numbers, if you will, thresholds, lower and higher thresholds. But on the flow chart that I submitted in my direct, that's basically the pre-construction permit. So to go into depth would be a very long conversation, and I don't have that information in front of me. But the site characterization is going to be very important, and the other steps after that. But basically, what I'm saying is they're going to be looking at predetermined guidance factors. Anything that falls outside of their scope will first be looked at for internal experience. And then anything outside of that will be contracted out to specialized contractors.
Thank you. So you said there's still work on some internal guidance that needs to occur to help permit these. Do you think that would be useful to have that guidance more in rule so that it's more clearly stated?
In general terms, when promulgating a rule, you don't want to get too specific because it might limit people in the future, new technologies, findings in the future, to where you leave that kind of open-ended but still protectory of what you're trying to protect, i.e. USDWs, et cetera. So, there are some places that I think, the conversation has taken us over the last few days where I think we can be a little bit more subscriptive. But in general, in my experience and what I've been taught since entering the regulatory environment about 5 years ago, is that you want not to be specifically vague, but you want to leave some room for future state scenarios.
Thank you. So I have a question about the contractors. Would those be on a price agreement to review?
There is a
Class six?
process. Yeah. Sorry, didn't mean to cut you out there. So there is a process for that. I don't know if that would involve a price agreement, but I would probably be involved in reviewing whatever that process entails.
And how often would contractors be reviewed? How often would they be renewed?
In my experience, I believe that there is a re-upping at a predetermined rate, like every year, every 3 years, et cetera. So, I don't know what our procurement people would decide there, but they probably would land somewhere in between the every year to every 3 year model.
Okay, thank you. And I believe previously you said that the funding for these permanent positions and any contractors will be coming out of the general fund or grants, correct?
Correct, yes.
Has the OCD contemplated having a permit fee to help cover some of these expenses and help cover the review process?
We've had discussions about it. I don't know if there was time logistically, because you would have to bring that to the legislative body in order to change permitting fees. The only permitting fee that we would be collecting is under statute, and forgive me, I can't quote the actual statute, but it is for fluid injection wells, and it would be a $500 fee for the APD, and that's after the success of a permit.
Okay,
Excuse
thank you.
me, let me clarify that. It is a $500 fee for the C-108 application, and then another $500 for the APD if it was on state property.
Okay, thank you for that clarification. So I have some other questions about records and confidentiality, which I think probably apply best to you. Within the rule, it seems like there are time limits of when data will be held for, and then it can be released after that. And it seems like retaining all of the data and like the injection pressures and the composition of the CO2 stream, all of that would be very important to keep in perpetuity because, what happens if there's an issue in 100 years? Is there plans for the OCD to retain that information or make the operator retain that information?
Yeah, so we are in discussions right now internally about where to house that in the first place. For very long term, as you bring up, which is very important, to have access to that. We are still deciding if that's going to be a third party data warehouse or if that's something that we can handle internally. Again, that's kind of got to go through the procurement process as well. But either or, I believe the intention is to at least keep the data a buffer period past the 50-year PISC.
And I could add specifically, it spells out 10 years after the end of injection.
Do you think it should be held longer than just 10 years, though?
I mean, holding any record longer than what is recommended is always good, in my opinion.
Does the rule say up to 10 years, or could it be extended?
I'm not sure. I'd have to find the exact text.
Yeah, the text is on page 8 of section 3, and it just says, this one's all modeling inputs and data used to support. Has to be retained 10 years after site closure.
Does it say up to? I'm sorry.
Up to, yeah.
Up
so
to,
that's
yeah.
a minimum
Okay.
is 10 years.
The minimum is 10 years. Do you think it would be better to increase that time in the rule?
That's something that we can look at. It would be more stringent, so it would be doable. So yeah, we can take note of that to see if New Mexico would rather have a longer retention period.
Okay, thank you.
Mm-hmm.
So there's been some significant discussion about confidentiality, and I'm just wondering how potentially affected people, stakeholders, or landowners or property owners would be able to make an informed decision about potential damages if they can't see the data. Do you have any thoughts on that?
Yeah, so we have talked about this internally, and I believe our plan is to take some legal resources, look at the statute, look at what is required to be submitted during the different phases of the application, and have operator guidance or just general guidance spelling out for internal review purposes, to make sure that the reviewers in the OCD have a guideline of what they can release and what possibly they couldn't upon request of the applicant. So our goal is to do that sooner than later, so we know how to build out those flows in the permitting process. So I know it doesn't answer your question, but it's still going to take some statute review by our legal department to determine what those are and are not.
So if someone was to file a protest, would they be able to see that information, the confidential information?
It depends. So right now, and I'll paraphrase, it basically says that the applicant can claim confidential business information. If it falls under one of the protected categories in our statute that it is confidential business information, then we have the obligation to redact that. So if somebody files a protest, then I would assume that would be redacted. I'm not sure. I think it's more of a legal what happens during discovery of a hearing or anything like that. So I couldn't speak to that.
Would a operator be able to say something is confidential if maybe it would have like an environmental impact and not share that?
I'm not sure. I would have to look and see if that was one of the protected categories. I mean, not me myself, but the legal department, of course.
Okay, thank you. And as far as reporting, right now the OCD with other injection wells, they have monthly reporting of their injection amounts. Is that something that the OCD plans to do with Class 6? It seemed like the reporting requirements were more spread out for Class 6.
Correct. Yeah. So we are currently visiting with our in-house developers right now about how to be more granular, because I believe the rule calls out for more granular reporting time periods. So we are laying that out for a plan forward, and that kind of falls into, okay, are we housing this? Are we going to house it first? It will be a portal that they report to. Is it going to be a Band-Aid of a document until we get that built out? But yeah, we are thinking through that of where that's going to be housed, but we are aware that it's going to be different than other injection wells.
Do you think, strike that. So there's annual reporting requirements and compliance reporting requirements. Will those be available to the public to see on the OCD website or posted somewhere?
Yes, just like any other thing that is submitted to us that of course is not claimed as confidential, will be available to the public. It will most likely, and it could be different, as we work through this process, be in the imaging system on the particular wells link on our website.
And will reports of noncompliance be shared with people who might be affected?
Those are currently, at least the pre-enforcement notifications are currently imaged to the well file. As far as like a notice of violation or anything that moves through our legal department, I couldn't speak to. I know that there is a process there, but I don't know if that is, public information until it hits a certain point in that process.
Okay, thank you. So the plan is to have a website similar to what the OCD does now for wells with all the well files and injection information?
Yeah, so holistically, what we're going to try to do is use our existing infrastructure as much as we can, but where the rule dictates that it needs to be different, where we have in-house developers that will build to our needs.
Okay, thank you.
Uh-huh.
And as far as confidentiality, would the OCD be willing to share data and permit application materials to the State Land Office or the BLM if they're affected?
Sure. I mean, as long as it doesn't fall under that category, right, after the legal review. But anything that comes to us that isn't in that category is public information.
Do you think having some clarification in the rule that some of this data could be shared with affected state agencies or federal agencies might be useful to help clarify that?
If it's needed, I would say, but anything, and what we're going to try to do is do a more digital footprint rather than, PDFs and such nature. But, I do believe that there are some verbiage and agreements and things like that anything that you do submit to us is public, right, and in a database. But if it is needed, and your suggestion is, to add that somewhere in there for more clarity, we'll definitely be open to that.
Okay, thank you. So I think I have a few more questions about compliance issues. Let's see. In 42, which is Exhibit 2, let me get there. So 4212.
Page 12, it looks like.
Yeah. 12. So then 12C 2. Oh, sorry, that's on the last page, on page 16.
Okay.
So here it says, any schedules of compliance shall require compliance as soon as possible and in no case later than 3 years after the effective date of the permit. Do you think 3 years is too long?
Can you tell me what subsection?
Oh,
where-
sorry, C2. And it's on
Any
page
schedules of
16.
compliance shall require compliance as soon as possible. Later than 3 years. So when we send out our pre-enforcement notifications, there's an internal deadline or a written deadline on that for 60 days. I think what this text is getting at here, and chime in anybody else that reviewed this section in more detail, is I believe that 3 years is kind of like the last, like that's your limit on to become in compliance. We are open to tightening that up.
Do you have a recommendation for how stringent that should be?
Well, without looking, so this is a general schedule of compliance. So it would depend on the type of out of compliance. And I just keep using, your sign isn't right, as an example. You can get that done in a month, right? Other things, would require a timeline to be submitted to the OCD for us to approve. So I think even if we did tighten that up to, say, 1 to 2 years or a number of months, that it would allow the applicant or the operator of that well to submit those compliance plans to us, even if it did stretch out. But I don't believe that you could go past the 3 years because that might create a stringency issue.
Okay, thank you.
Uh-huh.
And in part 13, which is also on page 16, is there anything in this rule that will prevent any other person from bringing suit or seeking compliance against any person in violation of the program requirements?
So can you elaborate a little bit on that?
So can somebody who might be affected by the Class 6 permitting bring suit against the
like in district court or to OCD or
like district court?
well, let's see, I'm looking at
I don't
B here.
believe Mr. Wrinkle can answer that question.
Okay.
The text of the rule is not going to trump any statutory rights of appeal or complaints, but that's something, if asked, we can address in closing briefings, but
Okay.
Mr. Wrinkle is not able to opine.
Okay, yeah, I would appreciate that being addressed. Thank you. Okay, so I think I'd like to jump to USDWs now, and I'm not sure who might be the best to answer these, but feel free to jump in. So is the ultimate goal of carbon sequestration to keep the CO2 within the permitted injection zone?
The objective of the Class 6 regulations
Yes.
are to be protective of USDWs and that it is a requirement that the fluid remain within the designated injection zone.
So I believe this was discussed yesterday, but is it the OCD statutory duty to protect correlative rights in New Mexico?
Correct, yes.
And do you suspect that carbon sequestration will occur in areas of multiple stacked resources, such as helium, geothermal, hydrocarbons, and SWDs?
I mean, they may be permit applications in those areas, but if there is a commercial, provable commercial commodity in the horizon, then, you know, they're going to have a lot of difficulty getting a permit.
What about not in the horizon? What if higher up, but would still be in the same area as the carbon sequestration?
You mean like above the combining zone?
Yeah, let's say there's an oil reservoir above where the carbon sequestration is happening.
Yeah, yes, that could potentially be the case.
So do you think if CO2 leaked out of the unpermitted injection zone, there could be damages to another's oil and gas or helium or geothermal operations, either their actual mineral resource or like the wells accessing those mineral resources?
If there was a breach and it did, well, it depends on the amount, of course, but it does in potential have the ability to, what's the word I'm looking for, decrease the value.
So do you think if there is that possibility that it needs to be stated more clearly in the rule that the areas should not, the protected areas should not only be USDWs, but also correlative rights, such as other mineral rights?
I could speak to that. One of the other key points is that the number one is to be protective of the USDW, and the second one at the top level is no communication between formations, and that's open to all layers of that depth of that casing.
Do you think that should be repeated more often in the rule, because a lot of areas in the rule only contemplate protecting USDWs?
From my viewpoint, at the top level, it just defines the overall goal, and the rest of it does discuss that through the more specified means of how to ensure that, such as the cementing and verifying cement in place. So my take would be, I think it follows fairly logically, but I can see your point that could add additional if you wanted through the language.
Okay, thank you. And so that kind of brings me to emergency notification. And let's see, I don't have where this is. Hold on one second. Sorry about that. I should have wrote down where this was. Thank you very much. Exactly, thank you. So in here, it states in part 1, as part of the permit application, the owner or operator must provide the director with an emergency and remedial response plan that describes actions the owner or operator must take to address movement of the injection or formation fluids that may cause endangerment to a USDW during construction, operation, post-injection site care periods. So it doesn't make it clear that there's an emergency response for if CO2 leaks to the surface. Does this rule read that they only need emergency response notification if it's endangering a USDW?
Yeah, so my interpretation of that section is as part of the permit application, the owner operator has to spell out how each one of those stages will keep that from happening. So each one will be specific into, again, during construction, we're going to drill a certain way, we're going to cement a certain way, and then through operational stage, here are all the steps we're doing on a proactive basis. So it's less of the reactive response versus the planning part in this section. So that's my understanding there. And if you don't mind reiterating your question for what to do, like how to respond to CO2 in a reactive situation, is that right?
Yeah, so if CO2 is leaking onto the surface, will that be an emergency response and make sure people are notified?
Yeah, at that stage, if it's leaking on surface, the earlier sections has a requirement for immediate cessation of injection to stop the source and to react if there is a leak on surface also. So the response section is what to do if you do have it on surface, more from a environmental health safety response standpoint and less from a well construction standpoint. And again, the immediate response that's dictated is to stop injection immediately.
Pardon, I'm so sorry to interrupt. I just wanted to object to that characterization of the rule. We don't believe that there's a part of the rule that requires immediate cessation of injection if there is a surface leak.
Yeah, if there's a surface leak, you have a USDW in between the injection zone and the USDW. So if an operator is aware of, number one, if an operator has concerns that there may be impact to the USDW, which is below the surface, they must notify and begin investigation. But if there's knowledge that there has been a leak to surface or through the USDW, at that point you have to, even before the surface, you have to cease injection.
Can you, I'm so sorry, and then I'll stop. Is that in the rule itself?
Yes, it is.
What section?
Let me find that.
Sorry.
It's under the operations section, I believe, but let me confirm. Yeah, I'll take a little time to find it, but I know it's there.
Page 14.
Yeah. And that's on a shutdown. If there's a lack of mechanical integrity, immediately cease injection.
Are we clear?
Just to clarify, that would be an implied reading under that provision in 1915 43(9)(I)(6).
Are you testifying,
It says-
counsel, or is this
That's a question. That's a question.
Right. So it says immediately cease injections. What?
Yes.
For lack of mechanical integrity.
But,
Okay.
but not if there was a surface leak, just for the same. Never
Yeah,
mind.
so any impact, so to clarify a little bit more, I think that's a good question. So mechanical integrity is defined as the assurance that you have a barrier from the tubing to the outside of the casing. So if you know, or if you have concern that you have lost, so the tubing going through the center of the casing, if you no longer have mechanical integrity, that's well before something on the surface. You know that there's a loss in a barrier in the tubing as well as the casing, and it could be coming to surface or possibly could go to surface. So at that point, you're required to cease operations. So that's even before known loss to the surface.
Okay, thank you so much.
Yeah, thank you.
All right. Commissioner Chosky, would you like to resume your question?
Yes, thank you. So this is kind of along the same lines. In 19.15.43.9 So in the same area, but part O, which is on 21. Oh, I'm sorry, this is in a different area. This is about the 24-hour, when there needs to be 24-hour reporting. So the permittee shall report any non-compliance which may endanger health or the environment, including, and again, in here, it just says, any monitoring or other information which indicates the contaminant may cause an endangerment to USDWs, or any non-compliance with a permit condition or malfunction of the injection system, which may cause fluid migration into or between USDWs. That doesn't specify leaks to the surface, and I'm wondering if that should specify leaks to the surface.
Can you, which section is that again, if you don't mind?
Yeah, hold on, let me find it.
Are you on number 303, A, B, C, D?
It's in the reporting section. I'm sorry, it might be
Okay.
in a different spot.
Well, first, what I'll respond to while I'm on that one is 03, A, B, C, D is if the owner or operator obtains evidence that the injected carbon dioxide stream and associated pressure front may cause endangerment to a USDW, the owner or operator must, A, immediately cease injection. And again, that's to my earlier point that the USW is even before the surface. So, and if an operator were concerned at surface, there would be a concern immediately at the USDW. And then they'd have to take all the steps notifying 24 hours and identify and characterize the release. So which page are you on though?
I have a question.
If I may, just for the record, Mr. Eels responded about a different section. If you could just identify for the record, because you said the section and subsections, but if you can give the exhibit and page number so we can know where your answer came from.
No, thank you. So 1915-43, O, 3A.
Thank you. Couldn't there be a case where CO2 might leak to the surface and not endanger USDW?
I think that would be a very rare event. The only way I could see that happening would be, possibly up through the casing, internal casing, or a cementing issue in the USDW, which would be very rare if that were to transport but not endanger the USDW. So I think if you were to have that loss, you would associate it to endangering the USDW. But I could see, I don't actually see a downside with adding the verbiage surface to this, right?
Yeah, I'll just add to that I can understand the scenarios you're speaking to, and it may make sense to add that. It may be a legal determination of what the statutory authority is. It's the only thing I would add to that. So that would be something we would need to check.
Okay, thank you. I'd appreciate checking on that. And how is the area where there needs to be an emergency response ready to go? How is that area defined?
I can respond. It's within the area of review and the activity itself.
Okay.
So again, yeah, where you might endanger the USDW, which would then fall back to within the area of review.
Okay. And
again, I'll reference it's 1915-43-01.
thank you. So CO2 is heavier than air, correct?
Yes.
So what if there is a leak of CO2 at the surface, and what if it migrates into an area of lower elevation that might not be within the area of review?
I think that's a good point, that it could possibly, if there was a leak that would extend past that and settle into a low area, then, and no wind conditions to move it on, it could create a risk.
I'll just add that the answer to your question about the area that is covered is somewhat project specific and would be defined in the project's emergency and remedial response plan. So I would look at the area review as a minimum, but the director would have the discretion working with the applicant to define a separate area.
Would there need to be modeling done to help understand where CO2 might migrate on the surface?
So you're talking about, the question would be related to like air dispersion modeling?
Yes.
You know, I know that that's not a common thing for other types of releases, you know, as far as methane or other types of sources. So it could be done, but typically it's not done to define an emergency response plan for areas.
Do you think that should be something that's included?
I'm not sure in this situation. Do like the point that you need to, and you're creating that plan, understand low-lying areas or low wind areas to anticipate that. But in my mind, air dispersion modeling for air permitting purposes gets into a lot of complicated analyses that wouldn't necessarily be as helpful as just an basic understanding of physics and where there may be a low area where there may be pockets to consider, would be my thoughts. I think it would be it'd be the incorrect tool for the goal that we would be wanting to achieve.
Do you think there should be some text in the rule saying that the emergency response area should be project specific and not just be the area of review?
I would need to read through to make sure I'm not missing something real quick.
Okay, yeah, thank you.
You know, I tend to lean towards that being prescriptive below what's there now, and reading that you need to do, again, identify the chain of command, well-related issues we talked about earlier. But I can't see how that would be a negative to add that, really. I could see it either in guidance or in the rule to ensure just one more layer of specificity to do that site specifically. When I read it, that's my understanding of what the intent is, but if it's not clear, that's something we can consider to make more clear.
Okay, thank you. And I know this was brought up by a couple other witnesses in the testimonies, but do you think that there should be buffers around schools or towns or anywhere where there are a lot of people to help minimize potential environmental and human health safety hazards?
I think that any buffer around sensitive areas is a good idea. Currently, this is a legal determination, I believe, that our authority for sites or siting is limited. So currently in oil and gas permitting and any other permitting, we rely on local municipalities, whatever their regulatory guidance is there.
Do you think it would be helpful for the OCD to provide maybe maps showing where Class 6 permitting is maybe more likely to occur?
I don't know if our interpretation would be, I mean, we can make informed decisions with experts, right? But I don't know if that's our place really to put out there.
Okay, thank you. Just looking at my notes. Let's see. I guess kind of on the same vein as talking about leaking to the surface, can you remind me, is air measurements for CO2 leakage mandatory at the wellhead?
I would actually probably prefer to find the exact testing and monitoring section where this is covered, so
Okay.
I think I can do so fairly quickly. It's on Exhibit 3, page 16. It says, "The director may require surface air monitoring to detect movement of carbon dioxide that could endanger a USDW, including in oil and gas fields or other areas with a high density of legacy wellbores." So it's left to the discretion of the director. It's not required in all cases, to answer your question.
And again, it sounded like it was only to monitor for dangers to USDWs. Is that how the rule reads?
That is what the text of the rule is, yes.
So do you think that should include not just endangerment to USDWs, but also leaks to the surface?
I would have the same answer. I say potentially yes, subject to a legal review of the statutory authority of this rule.
Okay, thank you.
Oh, sorry.
And okay, let's see. So in 1915, 43, 9K, so this goes into some of the testing and monitoring requirements. For part 1, it says that the analysis of the carbon dioxide stream with sufficient frequency to yield data representative of its chemical and physical characteristics. And I'm wondering what sufficient frequency means and if that should be better defined.
In this case, that is not defined in the rule, and it would be project-specific determination, and that would be part of the applicant's testing and monitoring plan and would be a condition of the permit. But it would be ultimately up to the director or his or her designee to define that in the final permit conditions.
In some of your experience looking at other permits, how often is that actually happening?
I would say quarterly would be the first thing that comes to my head for a detailed compositional analysis. There are some projects that actually have continuous injectate monitoring for more limited suite of analytes, in addition to a quarterly laboratory analysis.
Do you think there'd be a time where testing it yearly instead of quarterly would be the best option, or do you think quarterly is the best option?
I just didn't quite hear the first phrase of your question. Could you just, I'm sorry, repeat the question?
Is there a time where maybe you'd want to monitor annually instead of quarterly?
Less frequently.
Yes.
I really think the reason why I would see this as project specific is there are some operations that are taking CO2 from multiple facilities into a common pipeline. There's a higher chance that variability of the injectate would change frequently. If it's the same plant producing the same gas over time, I could see after a few years of monitoring and it being the same every quarter, there may be the need for some flexibility to move to an annual sampling.
So So doing quarterly, just in the rule, just saying quarterly testing, you don't agree with that?
No, I would agree with it as written that that is something that should remain flexible in the rule. But ultimately, a permit condition for each individual project.
Okay.
And I would add to that from experience as well, that you'll have some situations in which it's one stream, it's one process, and it doesn't change for years. And you'll have others that will have different sources of CO2 that would change more frequently, and it needs to be adjusted accordingly.
Okay, thank you. And I know this was brought up yesterday, I think, about soil CO2 monitoring. And why is that not required?
Just to clarify, it actually is required. So it's not required in the federal rule. That's an area of increased stringency. And I'm pointing again to Exhibit 3, page 16. Number 8, soil gas monitoring is required to detect movement of carbon dioxide that could endanger USDW.
So again, just pointing it out again that it's only for USDW, that it could endanger USDW, not at the surface.
That is the text of the regulation as written, the proposed regulation.
And the intent of the way it's written is that it is required to detect movement. So it is something we did. It was more robust to require soil gas monitoring.
And how often would that need to occur?
Again, that's not defined in the regulation as proposed. So that would be a project-specific determination in the testing and monitoring plan.
And how would there be, I think I remember you mentioning this, that there are some baseline measurements that need to occur before?
That is not a rule or regulation requirement as written, that there be a baseline monitoring. In practice, I think both the operator would also really want that baseline data so they have something to compare against in the future. So it's not a it's not a rule requirement, but I do think it could be a permit condition, and in practice, I do believe there would be baseline data that would be collected.
Okay, thanks. And I guess how long do you think that that baseline data should be collected for?
I would really leave that to be project specific, and I would be hesitant to mandate a lengthy baseline monitoring period. So I would leave that to be project specific.
Does CO2, the amount just like naturally in the background, does it change with the season depending on the vegetation?
It does, yes.
So it'd probably be prudent to ask for a longer baseline of CO2 measurements, correct?
Well, there is some seasonality to CO2 measurements, as both Mr. Yells and I have actually been in the field doing this. I would say, though, that the operator would have another option of collecting soil gas data outside the area of review as another measure of an area and seasonal fluctuation that's not potentially impacted by the project. That also may be more relevant because those things can also have long-term trends. So 13 years into a project, I may prefer that than looking at something from a long time ago. So that's one reason why I would leave that flexibility, though, to that.
Yeah, and what I would add is, we referred to it earlier in earlier testimony. Baseline would likely begin after a permit is issued. An operator wouldn't want to start that not knowing if they were to have a permit. So then at that point, you have a 2-year time period to get the well. And so I would say somewhere within the 2 years. I totally agree with what Greg's saying. It's going to be very dependent upon the situation, access, and the area itself. But like he said, we both have this experience, and it's very interesting to see the seasonality of how much CO2 is in the soil and winter versus summer for all those seasons. So you want to get that trend line going as early as possible. To his point earlier, everybody involved, it benefits to begin that. So then you can identify if there's any variation or anomalies.
Okay, thank you for that. So in part 10 on page 16 is talking about seismic monitoring. And I guess kind of again, New Mexico, the seismic network in New Mexico has areas where there are not seismometers to understand the baseline of seismic data, especially in areas not in the southeastern part of the state. Is part of characterizing the seismic understanding the baseline seismicity, and would that be required to be monitored before the injection starts?
Yeah, so again, it would follow a similar path. In my experience with the permitting process now, and would see it going the same way with this requirement in number 10, the permit conditions would require a seismometer specific to that project, but you would not install that until after the permit was received, typically. And then you would have that 2 years of baseline from that seismometer, but also it's very important to understand what's happening with other area seismometers to be able to triangulate and understand the baseline. I do know in the permitting phases, one of the things that's in here earlier is seismicity has to be considered as part of your permitting process, which also gives you some of that baseline from a general standpoint. But once permitted and in your conditions, then it's specific to your own operation and gathering that data.
So if they waited to start monitoring for seismic for when the permit started, what if they are able to drill and get the project going within a few months? That wouldn't be very much of a baseline.
No, and I think that's a good point, and I think it's just the nature of the conditions of ensuring that you had that permit first, but then you also have a fairly broad array of seismometers in New Mexico, especially in these areas that we're talking about. They're putting more and more in, but it's not, my knowledge of the areas that we're talking about, there's good data that's coming in that can provide a good baseline.
I'll just add that on this and the soil gas, there is the opportunity for clarifying some of this through guidance.
Do you think it should be more clarified in the rule, though, rather than guidance?
I think the reason guidance has some advantage is that there's some additional flexibility there. And in my experience, there is discussion of baseline fluid sampling in the EPA guidance that I think is helpful. And these are just two areas that are kind of more stringent in the New Mexico rule. And so I may defer to OCD, but I just like to point out that there is an opportunity to provide some clarity on the baseline monitoring and guidance.
Thank you for that. So what actually is required? Is it just one seismometer per injection well?
It doesn't specify, but it does say that it does have to occur, so likely that would be the outcome, would be one at the well.
How can you properly locate earthquake location or understand the focal mechanism of what type of earthquake it is with just one seismometer?
Yeah, and I think that's a good point and a good question, and it's the difference between detecting seismic activity or triangulating an epicenter. And that seismometer is detecting activity, but its purpose in itself and by itself is not to triangulate the epicenter of an event. In my experience, when there has been a seismic event, all the seismometers, including this one, would be part of the public database that then informs the triangulation of that epicenter. So to be very clear, the purpose of this section is to get a sense of seismicity, but not triangulation.
In part 10 of the rule, it does say that the seismic monitoring program must be capable of detecting and characterizing induced seismicity. Do you think one seismometer is enough to characterize induced seismicity?
In my experience, one is not, but then the system that it's with is. But I'll pass that to any other member of my team.
What if it's in an area where there's not existing seismometers? Do you think there should be stricter monitoring, seismic monitoring array guidelines in the rule?
I actually think it's a point, and it's something that Greg said earlier. I like that within a guidance document, I think that's where you could spell out that as an operator or as OCD, ensure that there is the ability to have the ability to meet this, and that could be yourself placing more or using the state system.
But if there's not clear guidance about how many seismometers need to be included, you can't properly characterize characterize an event. So how can that be in guidance? Wouldn't that need to be in the rule?
Yeah, I think I go back to my earlier testimony that OCD is approaching the primacy with its knowledge and skill set, and getting into the level of detail of seismicity and triangulation and these. That's why the OCD historically and currently refers and leans to the Bureau of Economic Geology for how they would approach it and use new technologies to be able to achieve the goal, but not with OCD, in my view, again, stepping out and portraying themselves as a seismicity triangulation expert and getting it in that level of detail and rule.
Sorry, did you say the Bureau of Economic Geology?
Yeah, Bureau of Economic Geology, New Mexico Tech, the state seismologist.
Oh, the New Mexico Bureau of Geology?
Yes.
Okay, thank you. And if there's a seismic event, does that cause automatic shutdown of the injection?
So under our current protocols, we have different SRA areas, and it depends on the distance from the epicenter. And we are using the state geologist epicenters now, and it shows a 50% reduction depending on distance, right? So you've got 25%, 50%, and then a shut-in, and depending on magnitude as well. But specifically laid out in the rule, no, that I think it points to the current New Mexico SRA guidelines.
The project's emergency remedial response plan would list out a very detailed response to earthquakes of different magnitudes. Typically, there's a very detailed table that provides response actions at earthquakes of different magnitudes.
And how, let's say that there is a Class 6 injection well in an area that doesn't have an existing seismic array. And would you expect the Class 6 operator to be able to locate an earthquake within a certain time period and understand it, to understand if it's tied to the Class 6? Is there like a reporting requirement for that?
I would say that if there was an initial seismic event in which it was detected with that seismometer, and it was known, and to these points, there's obligations in New Mexico through the seismic response to notify OCD and loop them in. I would say at that point, the normal response I would expect is an array being placed, or basically further actions being placed to determine what it was and then investigate where that did come from. And I know from experience in talking to what Justin's was referring to earlier, that's been something New Mexico has been extremely good at. It's why New Mexico has so many fewer seismic events, in my mind, in my opinion, than Texas when you cross the border. Is there's an immediate response, immediate notification requirements. The operators know they need to engage. And the OCD at that point looks at the different wells in the area and will ask individuals to bring down and try to triangulate and resolve that problem. So I think it's a skill set that OCD has shown themselves at being very adept at in conjunction with New Mexico BEG. So I guess a long answer, but I would expect if that particular situation would happen, which would be rare, there would be a response to investigate.
And what would happen if there was a Class 6 well injecting into the same zone as an SWD well and there was a seismic event?
Yeah, very similar to what I was explaining. If you had multiple wells, which is what OCD is familiar with, is you have a seismic event at some epicenter, you look at all injection wells in the area, their permitted volumes, their permitted pressures, and the records of their most recent injection, and begin to, and the zones, deep or shallow, to try to triangulate where that epicenter occurred and then take action from a wisdom standpoint to kind of laser in on where the problem is.
Okay, thanks. So one more question for this part. In part 12, also on page 16, it says, the owner or operator shall periodically review the testing and monitoring plan. How often is periodically?
I'm just going to read the whole paragraph.
Okay.
It states here on page 16 of Exhibit 3, an initial review of the testing and monitoring plan shall occur 2 years after injection begins, and in no time may exceed 4 years.
Do you think? Oh.
It also says amended plans or demonstrations shall be submitted within 1 year of an area of review evaluation. So it's also tied to that review cycle. And then it goes on to list other conditions in parts 12, A, B, and C.
Remind me, was this an area that is New Mexico specific more?
Yes, this is an area of increased stringency compared to the federal rule.
Okay, thank you. Madam Hearing Officer, would it be possible to take a break at this point?
It would. It would. Let's see. It is 1:55. Come back at 2:10.
Great, thank you.
Let's come back from the break, please. Commissioner Ostrowski, do you have additional questions?
Yes, I do. So I want to get into something that hasn't been discussed too much, which is exempted aquifers. And that is in 19.15.43.8.
You mind repeating that for me just real fast?
Yeah, 19, 15, 43, and number 8. And let me see if I get the page.
Page 3, is that correct?
Yes, thank you. Oop, I'm sorry about that. So, who makes the determination if a reservoir should be exempted or an aquifer?
My understanding is ultimately that decision remains with the US EPA regional office, in this case, Region 6, but they do incorporate feedback from local entities, in my experience.
So the OCD won't be deciding where there might be a possible mineral resource, such as oil and gas or geothermal?
I don't have a ton of experience with the aquifer exemption process once you start working with EPA, but it is my understanding that the ultimate decision of whether or not to grant an aquifer exemption is with EPA. But I would note that new aquifer exemptions are not allowed under the Class 6 program. And the only way that an aquifer exemption would become relevant is if there is a previous aquifer exemption for a different well class, and most specifically Class 2. And EPA, in their framework, does allow for expansion of an existing aquifer exemption if it was for a project that was previously injecting CO2 for Class 2 and now wants to expand into a Class 6 project.
So how would, if, let's say, if there is an aquifer that the OCD thinks should be exempt, how would they bring that up to the EPA? If there's like a New Mexico specific thing, like a geothermal aquifer?
I can speak to this unless there's someone else on the panel with more experience. In my experience, it's the operators that typically come in for an aquifer exemption application, though I have seen where the EPA has at least solicited comment from the state during the decision making on that.
So if there was, let's say, like a geothermal operator, they would have to go to the EPA to try and protect their aquifer.
Okay. I'll just back up a little bit. An aquifer exemption would allow for injection into what would otherwise be an underground source of drinking water. So when I said an operator would come in for an application for an aquifer exemption, they would be the party that is attempting to inject into a potential USDW. Just to be clear, if it's an entity looking to protect groundwater, that would not be through the aquifer exemption process, is my understanding.
Sorry, I'm just thinking through that.
Sure, yeah.
So right now, an exempted aquifer could also be a mineral hydrocarbon or geothermal producing area, correct? That's, unless I'm is that what the rule says? That
may be a reason for, or one consideration in an aquifer exemption application or approval. I might want to read through the text you're referring to, if you see something specifically.
Yeah, it's in A1. Are you on the right page? I can tell you, it's on page 3.
Exhibit 2, page 3?
Exhibit 3, I'm sorry.
Exhibit 3, page 3?
Yes.
I'm sorry, go ahead.
And it's in A.
Yes.
And B, 1.
So, I'm sorry, A and B1? Help me out.
Yeah, A1, B,
there we
I,
go.
sorry.
Yes, that is a criteria that's listed in the text that you're citing.
And so New Mexico doesn't have any control over identifying those reservoirs?
I'm really not the best person to speak to the actual decision-making process when it comes to EPA's consultation with the state on this topic.
Okay. So if a class 6 was going to be permitted into an area that might be used for geothermal, but is not include, like, how would they prove that that this should be an exempted aquifer?
Again, in this case, the operator would be requesting an aquifer exemption only if they actually wanted to inject into that zone. And there are no aquifer exemptions allowed under Class 6 other than expansions of existing aquifer exemptions.
Okay.
I hope that answers your question.
I think so. I might come back to it if
Sure.
I think
Yeah.
a little bit more about it. And another question I have is that I'm assuming the amount of total dissolved solids is coming from the EPA, correct? For, let's see, in BV, just further, a little further down.
Yes, this is EPA regulatory text.
And I mean, there's some areas where they're desalinating water for much higher TDS. Do those areas need protecting, or would that have to come from the EPA?
I think if I understand your question, I may kick this to someone else on the panel, but I just want to make sure I understand the question. The UIC regulations more broadly and the Class 6 regulation prohibits injection into a USDW. One criteria to define a USDW is that it has less than 10,000 milligrams per liter TDS. And is your question, what about potential water resources that have greater than 10,000 TDS?
Yeah, what if New Mexico would want to access waters with a higher TDS that have already been injected into?
Yeah, I think it may be helpful to go back to the original definition of USDW, which has several criteria. It's on Exhibit 1, page 4. And it says that a USDW means an aquifer or portion, A, which supplies any public water system, or which contains a sufficient quantity of groundwater to supply a public water system and has additional criteria. So I think under A, if there was a water resource greater than 10,000 that is supplying a public water system, it would meet the definition of a USDW.
So it would have to be already supplying water to a town, to a public water system, for it to be included in that definition.
I'm just rereading through this definition. Do you want to take?
No, I was just recalling it. It may have said future use, but I was going to verify that.
I think that the reading of this text does say that my reading of it, including Part 3A, B, and B 1, 2, and 3, would say that it has to be currently supplying. But I could be
Well,
corrected.
in in 1915-43-8, which is Exhibit 3, A1B on page 3. It says it cannot now or will not in the future serve as a source of drinking water.
But this is specifically for exempted aquifers, which is a kind of a separate definition than a USDW. So an exempted aquifer is what would otherwise be a USDW, but has been granted an aquifer exemption.
So no one could inject into.
No, it's
these
the
areas.
opposite of that.
Oh, okay.
An exempted aquifer you can inject into. So the operator would be wanting to inject into that zone. It is a USDW otherwise, but they say it's not really practical that it would ever be used for several reasons. And they have made an application for an aquifer exemption. That aquifer exemption was ultimately approved. And again, you can't have a new aquifer exemption under Class 6.
Okay. Okay, let's switch gears here. And I'd like to talk a little bit more about areas of review. So I'm going to reference Exhibit 3, number 9. C 1B on page 5. And B covers a map that needs to be provided as part of the permit. And I'm wondering why only information of public record is needed on this map and why proprietary information is not included. And it's in the last sentence where it says only information of public record is required to be included on this map.
I'm not seeing the word proprietary. Where is that at?
I'm wondering why proprietary data cannot be included on the map.
Yeah, and I'm not seeing the word proprietary, I guess. Is it in
It's
there?
not in there. That's why I'm wondering
Okay.
why is it only public information allowed?
Yeah, this is
included.
exactly the same requirement as the federal CFR on this topic. And I would say that there's other sections, like the corrective action section, where additional information on oil and gas wells are required and other things. So I'd say this could be looked at as the minimum for what should be included on the map. But on a project-specific basis, additional information could be requested by the director.
The other thing I would add to it from my take is that for an operator applying for a permit, it's stating that you're obligated to find all information that's publicly available. And there may be a private neighbor dug a hole in the back of his yard and you don't know about it, but you're not obligated to go ask every neighbor for, did you dig a hole and didn't report it? So my take on it would be that all information that's public record is required, but I'm not seeing where it's separating out proprietary. I see your point. But I think that's the intent from my view is from a permitting standpoint, you're obligated to seek out all public information.
Is this a map that would be shared with the public?
Yes, in the hearing process, your AOR and all information that you use in your hearing is publicly available on the OCD site.
Okay, so if there was a fault that maybe was found in proprietary seismic data, that wouldn't be included on the map to the public?
Yeah, I would say, so there wouldn't be a map, but if there was a fault identified in proprietary data, then it wouldn't have to be presented in here, according to this. But there's a lot of public information. Go ahead, Ned.
I'm sorry. On this particular map, I would agree with you. This is a very specific requirement. This map is I've had to create this map many times, and it is very specific. But there are other requirements here to identify faults and fractures, and typically the Class 6 application will have many maps showing faults and fractures. To the extent that there's no confidential business information or any other issues associated with that, it would be part of the permit application, and my understanding is ultimately part of what would be available.
Okay. So let's see, just a little bit more about 3D seismic. I know we've been discussing this quite a bit. So I know 3D seismic is not required as the rule's written right now. It is only needed at the direction of the director, correct?
Yes, that is correct. Yeah.
So if, let's say a company comes in with a permit and the director comes back saying, hey, you need 3D seismic here, that could potentially hold up the permitting process by a lot, because 3D seismic can, it takes a long time to cover those large areas and get land agreements from everybody. Do you think it'd be easier just to clarify that it should be required at the beginning of a project?
I think that the discretion is probably the best way forward, because in New Mexico, we have known areas, right, where we would require that, and then we have other areas that we don't know much about that we might want to require that. There's also areas that we know a whole lot about, right, that we might already have that public information to where we wouldn't require that. I think it's a case-by-case basis. To be more specific in the rule like this and some of the other questions that we've had, I think we understand them and we get the point. I think on this particular instance, I think what we did is we found a really good balance between what's in the rule and what we can do in permitting. And then basically what we always do in permitting currently with our other primacy and with this in the future is whatever we do in the permitting process, we rely on the rule that we can do that. So I think this falls under that umbrella as well. But there are instances right now where in review processes where we do make decisions on if 3D seismic is warranted or not.
And I guess just remind me again, what's the OCD's turnaround time for these permit approvals?
So the goal, I believe that we stated in our petition, was 0 to 8 months, right? I mean, it's of course not going to be 0 months, but let's just say 8 months is the goal. And, that's if everything comes in perfectly and, we don't have any kind of questions or anything like that. So it's, going to be extremely rare that happens. So, the permitting process, and I think I said this yesterday, is it'll take as long as it takes until we are comfortable that it meets all the requirements of whatever rule is promulgated, and that we are confident in the issuance of that permit.
Okay, thank you. Mm-hmm. So in the same area, so on page 5, C number 2, II. Mm-hmm. So it says in the permit that the location, orientation, and properties of known or suspected faults and fractures that may transect the confining zone in the area of review, and a determination that they would not interfere with containment. And I am wondering why only faults that could transect the confining zone are included in this review.
The reason for that is the concern over the leakage through the confining zone, and the confining zone not having integrity to contain the injected fluid. So the primary focus would be on any transmissive faults or fractures that may lead to leakage out of the injection zone.
Could there be a case where there could possibly be a fault or a fracture above the confining zone and CO2 leaks from the well into another zone and then transmits up a fracture that was not included into this review?
Yeah, in my experience, the combination of the requirement for the sort of publicly available faults and the identification of faults that potentially could penetrate the confining system really kind of covers all depths, and all faults are disclosed at the end of the day.
Do you think just in the rule, maybe it should say instead of may transect the confining zone, just be all faults in the area of review? Or faults or fractures?
Yeah, I think that may be reasonable, something we can take under advisement.
Okay, thank you. So in this same area, in letter E, same page 5. So it requires that maps and stratigraphic cross-sections indicating the general vertical and lateral limits of all US DWs, water wells, and springs within the area of review, their positions relative to the injection zones, and the direction of water movement where known. And I'm wondering if in these maps and stratigraphic cross-sections, there needs to be an inclusion of any mineral or geothermal resources so that the people reviewing the permit know what other mineral resources might be in this area.
Yeah, I see where, being more specific would help here, but it's kind of, it's built in because of the Oil and Gas Act. That's kind of one of the first things that we would look at is, where are those minerals at? Where would they potentially be? It is an internal guidance when we are looking at injection wells. For us the first thing that we look at is any waste or, potential causing of waste. And then, they would have a very hard time getting that permit, but I can see where you're coming from to be a little bit more specific there for the operator to provide that map.
Yes, and even if, like what was mentioned earlier, damages could potentially occur to minerals, even if the injection is not occurring or even if there are minerals, sorry, let me start that again. There could be damages to minerals outside of the injection zone.
There's a potential, yes.
And I know, you mentioned the Oil and Gas Act, and I know OCD permits wells related to that, all the class 1 through 5. I don't know, how would this work with ECAM and their geothermal rules and working with them to make sure that there's no issues with geothermal?
Well, we have a closer relationship with ECAM and the geothermal folks over there. And if it is classified as mineral ownership, the geothermal mineral ownership, then it would fall under our obligation to prevent waste.
So you would work with ECAM to understand where these geothermal resources might be to verify these maps submitted in the permit?
Yes, I believe so. Mm-hmm.
Okay.
One thing I would add, just from the permit requester's viewpoint, because of those things changing significantly in each one of these departments, it would be very difficult to make that a requirement to know the latest identified area for geothermal versus right now strat maps are required to show all the layers in the formations, and the formations are known for certain things. And then in your permit itself, you have to prove the confining zones to ensure that the CO2 stays where it's supposed to go. But to then add on the latest and greatest designation of a geothermal or some other things, that's definitely prescriptive in some areas where it may not even apply, but I don't know, I just would see a little bit of cautionary in that one.
Do you think that would be like a good starting point for the permittee to at least present, and then the OCD could verify?
I tend to think that, so I do know that the permittee does have to submit all the stratigraphic layers, and that's part of that AOR and their intended injection zone. I think at that point, though, based upon Justin's testimony, that the OCD is going to be much more tied to the other regulatory bodies as to what the purposes are for some of these. And to put that on an individual operator would be very challenging, if not impossible. So I do think going through the normal permitting process, it does identify where you intend to eject your containment zones, and then all other strat levels that are reviewed by the OCD. And I personally feel it sits best with OCD to do what Justin talked about.
I just want to verify, because in E, it just says that maps and stratigraphic cross-sections have to happen where there's USDWs, water, wells, and springs, not the entire geologic section.
Up above that in item C, it says information on the geological structure and hydrogeologic properties of the proposed storage site and overlying formations, including et cetera, et cetera.
In addition to that, I would point to the part in E where it says their positions relative to the injection zones. And in practice, those stratigraphic cross sections go all the way from the injection zone to surface.
Okay. And then in F, just below that, it asks for baseline geochemical data on subsurface formations, including all USDWs in the area of review. And I guess somewhere else it also talks about fluid samples, but especially in areas where maybe there hasn't been as much development, how would an operator or a permittee know that there could be an interval maybe of high H2S if that isn't sampled for?
I think that this would be covered under the distinction between the permit to construct and the authorization to inject. This would include all information that's available at the time of the initial permit application, but additional information would be collected during the construction of the injection well. And that information is required to be provided to the director prior to authorization to inject.
It seems like, correct me if I'm wrong, but it seems like in that before the authorization to inject, when they're collecting that data, is it only needing fluid samples from USDWs and the injection reservoir?
I would actually want to go to the pre-operational testing section if I could find it.
Yeah, let me see if I can find it too.
Yeah, maybe it's on page 12. Let me take a look.
Oh, I think I found it. It's 3 on page 13, I believe.
Yes. I'm reading through it. So I think this is broad enough to give the director the authority to require that information in the pre-operational testing plan that is part of the permit application, and other intervals that there may be of some concern.
Okay. Let's see. Okay, so now another area of review question is, we talked a little bit about yesterday, and we've seen in some of the exhibits that the CO2 plume will not spread out radially from the well perfectly. It has geologic constraints, correct?
I'm sorry. I was looking to also supplement my previous answer.
Oh, sorry.
Yeah, so I apologize. But also on page 12, Part H1 also includes additional information on collection of salinity of any formation fluids in all relevant geologic formations. So we'll just point to that as well.
Thank you.
And then I apologize, but I would ask you to repeat the question.
Oh, yeah, no problem. We discussed yesterday that a CO2 plume will not, spread out radially perfectly. It's controlled by reservoir characteristics, correct?
I think it's fair to say in most cases it's not going to be a perfect circle surrounding the injection well.
Yeah, and if the plume went out of the area of review, would that be grounds for a permit to be terminated or at least shut in until?
I think it would be grounds for an AOR reevaluation at a minimum. And beyond that, I probably would have to reference some of the text here. But I will say that in many cases, if not most cases, the area of review is larger than the plume because it also includes the area of elevated pressure. But any nonconformance of the predicted area of the plume and the actual area of the plume would be would likely trigger an area of review reevaluation.
Yeah, and I'll add to that to supplement his statement in that the requirement for a continual or a revisited area of review or a frequency of area reviews, you're going to identify if there's a concern that you're seeing that it might go outside of that original AOR and adjust it well before you're seeing it just go out, would be my take too.
And so it would continue to inject, correct?
Well, Mr. Hills brings up a really good point. The area of review, even if it was defined by the plume, is the plume at its largest extent, which is typically at the end of the project or even maybe many years after the project in the post-injection site care period. So the data that's collected at the early phases of the project may show that the model and the monitoring data is not in conformance 100%, but that can be true, and it also can still be within the area of review because the area of review is defined as the maximum extent ever over the lifetime of the project.
Yeah, and one thing I'll add to that, and that maximum extent is you have to take the most conservative route of the maximum permitted volume and pressure from day one, every day of operation for 50 years. And the likelihood of a well injecting at maximum volume is next to none. That's a limitation. And if you're that close to that limitation in your normal operations, you're right on the edge of a violation and being shut in. So normally there's a ramp up in time, and that area of review is extremely conservative. Then you'll stay within that. But then, in addition, as we pointed out, you have a frequency requirement to continue reevaluating the actual injection. And what you normally see with that is, again, if you've got a 50-year worst case scenario, and then you input your actual volumes and pressures, it's going to be much smaller.
Though, I mean, theoretically, the CO2 could reach like a channel sand that was previously unknown with higher porosity and travel faster outside of the area of review.
Yep, theoretically, you're right.
So, so it would be able to keep. I guess, how would you know if that was happening, if it was going outside?
So there's a requirement in the monitoring to, and Greg would have to help me on this, to identify, to be able to detect the plume and know if that's happening or not happening. So some common methods of doing that will be a baseline or a base walk away and understand the imagery before you inject. And then a frequency where if you want, you can take another seismic shot and see if the plume is, like Greg said, it's not going to be a perfect circle, but see what the plume characteristics are.
So what would happen in that case if the proper land agreements or leases weren't in place?
Well, I think that's part of that area review is there'd be a number of things you would have to look at if you're an operator when you perform and you see something that seems to be going a different way than what was modeled and what you understood in drilling, and you have to take those actions. So that's a good question, but each one will have a different possible action you may have to take.
So the well might be injecting in trespass then?
No, it wouldn't be if you're looking at things in advance. So I think where I'm trying to express is you don't wait until the very end because there's a requirement for a frequent area of review. And you would want to understand that, and it's required to understand it early, proactively, to avoid exactly what you're talking about. That's the point of an AOR, frequency of review.
But I mean, it still could be injecting for like 6 months before an area review happens again. And it could be like migrating out of the area review for several months before.
And Greg, you can talk to this further than me with your modeling. But what I would say, again, you're doing a worst case scenario of 50 years maximum volume. And a year from that point, it's going to, even if there was some form of worst case channeling, the volume is so negligible compared to that initial AOR, the likelihood is very low that that scenario would exist. But that's where that frequency then allows you to do reassessments.
Okay, but yeah, it still could happen, it sounds like, correct? Even though if it's rare.
Very, very rare, yeah.
And this is an area of increased stringency compared to the federal rule because of requiring the initial 2-year reevaluation after injection starts to address this concern. So like in my direct testimony, I talked about sort of how quickly you have to move through that truing up your model and your data. And so the additional stringency requirements for 2 years after the project starts and then no more than 4 years really makes you move through that process much quicker to address the concerns that you have.
Okay.
Yeah. And I think what you're communicating would be, so if there was a 50-year worst case scenario, radial or some shape, and there happened to be a channel of sand, there may be a line, in that amount that might touch something, but if it would be very rare if it were to happen, and if it would be this one strange channel. And I'm just not even familiar with a situation in which I've heard of that, occurring within a 1 or 2 year period just because of how conservative the AOR is.
Okay, thank you. And I guess in your experience of reviewing these, how large are area reviews like in general?
I'm sorry, I probably wouldn't want to be able to give you an area off the top of my head. I might want to go back and look at sort of what's publicly available out there. And it is very project specific based on the amount that's being injected and also the pressure condition of the reservoir prior to injection and the AOR delineation methodology. But I would want to go back and study my notes a bit. I think at some point I may have actually looked at this, but I don't know off the top of my head.
Okay. So if an AOR, let's say it could span, I don't know, without any examples, I'm just gonna guesstimate. What if it spanned 2 miles, let's say, or a mile? That would likely go over multiple land ownerships, especially because the plume, it won't be like fit into a perfect square like our leases are in section township ranges. So how could we even permit and drill a class 6 well without that framework to connect different land types?
So I'm just trying to understand your question here. So this would be, I think, taken care of in the pre-construction review, that you have the ability and right to those areas, right? Am I understanding that right?
So if you could ask it again one more time. So if it could have a 2 mile diameter or a 1 mile, a distance, let's say a mile, and there's multiple surface owners. So what was the question though?
So how could this be permitted if there's no unitization regulatory framework in place, if it's crossing multiple landowners?
Yeah, I can't speak to unitization.
Yeah, me either. I would have to refer to somebody with more experience with unitizations.
But as part of, would these be able to be permitted if there isn't land access already?
So what I can speak to is in a class 2 well, you do have to have ownership, you do have to have of the injection location, but you have to notify all parties that are affected within the AOR so they're aware of it and they have the right to protest or raise concerns. But there is not that requirement within that protocol. I'm not sure, how it would be different with this.
Do you think that should be a requirement, that a well can't be permitted until there's the proper land agreements in place?
Holistically, it sounds right, but I think this is, and correct me if I'm wrong, Jesse, you might address this in closing.
I think this is something that we will need to address in closing, and I have explained to the commission in the past that there are different parts of this program. We broke them up into logical chunks that relate to the same subject matter, the same evidentiary basis, and the same set of witnesses. We are moving forward with a rulemaking application related to the protection of USDWs and groundwater in the permitting process. So Mr. Wrinkle testified that the representation of the right to inject is something that the division looks at in reviewing permits. That's a permitting review and decision. If we're looking at something that's outside the scope of this, that's another question. The department is looking at unitization, the potential need for unitization. But we're talking about, in that context, we're talking about a fact pattern that involves percentages of willing and unwilling participants. We're not talking about that fact pattern here.
I just don't see how these can be permitted without having some of that in place already. But let's see.
I'll just reiterate what I said yesterday, that right now EPA Region 6 can evaluate permits in New Mexico. And the intent of this is to take on their review capacity.
Okay. There hasn't been any permitted wells, Class 6 wells in New Mexico yet, though, right?
There is one that I'm aware of that's in the permit review stage.
So about the area of review again, let's say there's, the area of review for a Class 6 well, can an oil and gas operator drill inside of that area review for minerals not in the injection zone?
You're talking at a different formation level?
Yeah.
Yeah, so absolutely a operator can drill into a producing formation such as the Wolfcamp and produce an unconventional well from the Wolfcamp, which is within, again, an area of review is latitudinally spatial. So those producing wells are naturally going to be within that AOR, but in a very different formation. Thus the importance of having the containment proof to be able to keep the injectate within the injection zone and contained.
So they could drill through a injection zone
Yes,
to
they
get to
could.
an oil and gas?
Correct.
And do you think, could that significantly increase drilling costs to have to drill through like a higher pressurized carbon dioxide zone?
No, it doesn't it doesn't significantly increase its cost. What happens is and again, in the experience that I have with this in the Class 2 arena, they'll be aware that this is part of the permitting process for their wells and their APDs. They'll be aware themselves and with OCD support and publicly available information that there's an injector in that area. Same thing with an SWD. They could be injecting in a shallow well, like the Delaware Mountain Group in the area I'm familiar in, and that they need to drill through that to get to the Wolfcamp. So what they'll do is anticipate that, and let's say that you need 8.5 pound mud to go through a normal formation, the Bell and Cherry Canyon, to get to the wolf camp, you would anticipate and you would use higher weight mud, maybe go up to a 9.95. But it's not a significant cost. It's just something that drilling companies are very used to, and being able to understand it, because they also know that sometimes you could be drilling through an area where there's been no injection, but there's just an anomaly, and the procedures and practices basically require them to, through a safety standpoint, anticipate that there may be an increase, and so they're well versed in, again, adding barite, doing things to make it heavier until they get through the zone and case it.
Okay.
This is, may I request a brief recess or mid-afternoon break?
Oh yeah, that's fine.
Okay.
All right, Mr. Chair, 3:10, is that okay?
Sure.
All right, 3:10. from the break, please. Commissioner Chowski, do you have additional questions of the panel?
Yes, I do. So I guess I still want to talk a little bit more about the area of review and the notification area. Oh, sorry. So do you think allowing a permit to be issued without notice to persons with mineral interests becomes a correlative rights issue?
Okay, without mineral interest, is that what you're saying? Or with mineral interest?
With mineral interests.
Okay, I was just trying to find the section where it says who needs to be notified.
Yeah, if you could find that, I'd appreciate that.
Yeah.
Do you mind repeating the question again?
Do you think that allowing a permit to be issued without notice to persons with mineral interests becomes a correlative rights issue?
I would chime in. I'll let Mr. Wrinkle testify as to the facts and the process for OCD's permitting decisions and determinations, but correlative rights and prevention of waste are that's calling for a legal conclusion. That would be a multidisciplinary determination, but the facts and circumstances of the permitting decisions and the specific notification requirements that address that, I believe, are within Mr. Wrinkle's or the rest of the witnesses' testimony.
Yeah, so to answer your question, I think I can answer anything specifically in Exhibit 1. I believe it starts at the bottom of page 5, and it's the public notice of permit actions and comment periods.
I'm sorry, at the bottom of page 5, you said?
Yes, and the title of the section is public notice of permit actions and public comment periods. So this is what we would be looking at to make sure that these listed entities were provided notice.
So I believe in 5B, it does mention the State Land Office, but I don't see anywhere in here that it mentions, it doesn't break down notification of mineral interests that need to be notified specifically. So that could be lessees, that could be depth severances that are put into county court, that could be different operators. Is that specified anywhere?
The only place that I think it would be covered is there's another subparagraph that is basically a catch-all. And let me, that is it E? Yes. Yeah. So E, and it's the last sentence of that, and for, let's see, not the last sentence, to give notice of action in question to persons potentially affected by it. But you are correct that it does not specifically call out mineral or surface owners.
Do you think it should specify that?
I think it's implied that anybody that has any activity or, dare I say, standing in the area of review should be noticed, and it specifically calls out, other state agencies, water supply folks, and just basically anybody and everybody that's in that affected area.
Who's going to be doing that notifications?
So that is up to the applicant, and then we would review those for completeness.
So you would ensure without the guidance in the rule that both surface and mineral estates need to be addressed, that the OCD would review those?
I think we would look at it to make sure that they covered every avenue within that area, because the way that this is written is kind of all encompassing at the moment.
Do you think it might be useful to just clarify that it needs to be notification of both surface and mineral estates and people with mineral interests.
I think it could be potentially useful for extra clarification. I think it is something that we can take under advisement and look into to see if that would add benefit to the rule text.
Okay, thank you. And would that review include, let's say, leases for different types of minerals? You know, there could be potash, there could be oil and gas, there could be water, or SWDs, depth severances, because those are recorded at the county level, you know, not at the state land office level or the BLM level. And would that need to occur to make sure that there's no correlative rights issues?
I think that internal guidance while reviewing, you know, any standard operating procedures that we develop in the review process would be all-encompassing of every bit of information that would be in that area now that would be available.
And so once this notification goes out, how long does a affected party have to protest or respond?
Do you have that info, Jennifer? It's 30 days.
Would you consider lengthening that time? That isn't a whole lot of time for a review.
Sorry, I'm just thinking of different
no,
things in my head.
Yeah, please, take your time.
Potentially.
It does state in under 4, public notice of a public hearing should be given at least 30 days.
Do you think it'd be good to just add, you know, just have it 60 days? And then that would just be the standard?
It's something that we can take a look at. I think we would have to look at some other areas to see if it jives. But, you know, with the text saying at least, I think that gives us a lot of discretion there.
Okay. And would the OCD consider doing a comprehensive review of all mineral resources and interests within 2 miles of the location of the permit? This could help aid in better understanding of possible conflicts that could arise.
I don't want to commit to anything right now without going and consulting with my technical team to see what benefit that would add, especially if, you know, the areas of review are such a spectrum in size. There could be some that are larger than that, some that are considerably smaller. So I just wondering, you know, if we did do a minimum of 2 miles, then, you know, what would that benefit? Would that give us any value really on site-specific projects?
May I ask a clarifying question?
Yes.
It's going to land on my desk. Are you asking, the question was, would the would the OCD consider undertaking a comprehensive review? From what I understood from some of the comments was the proposal for a minimum radius for the area of review. And I'm not sure if I'm confusing those concepts. So are you asking the OCD to undertake a comprehensive review of mineral and other interests? Or are you asking the OCD to consider modifying the area of review language?
I guess more modifying the area of review language to include some kind of extra buffer, but also, I mean, the OCD, to verify that the permittee got all this information correctly, they'd have to verify that they have covered all of the notices that need to go out, correct?
Thank you for clarifying. We'll discuss.
Okay. So let's say there's an SWD well that's injecting into a deeper zone, for example. And I guess if there was an SWD and a CO2 injection happening in the same zone, would that SWD well operator be notified?
Yes, as it's written here, if they fall inside that AOR, then they would have to be notified.
Okay. And I guess if that SWD was permitted, before the Class 6, and the pressures increase in the reservoir, would that SWD have to change their injection requirements based on the increase in pressure in the reservoir?
I believe that the incoming permit, and Greg, help me out if you can, is they would have to take into consideration the injection of the existing SWD and put that into their model, and not interfere with what is already permitted in the area.
And I can add to that, if there was an existing SWD injecting into the same zone, number one, to your point, if it was in the AOR, it would have to be area of influence, and under E could be possibly affected by the application. They would have to be noticed, and the maximum volumes and pressures that are permitted for that first SWD have to be incorporated into the new applicant's modeling. And so that in itself has already demonstrated a potential increase in reservoir pressure due to the maximum volume and pressure for the permitted life of the well. And so that basically the one that would be coming in new would be the one receiving the restrictions knowingly in the permitting process.
So is that anywhere in this rule saying that previous permitted thing, like SWDs, for example, would have priority over, or they wouldn't have to change their
Yeah, and I'll let Greg talk to this in more detail, but from my understanding, it's not in that level of detail, but in the permitting process, you have to understand the pressures of the formation you're injecting into, the fluid characteristics. And as the applicant, you have to consider that pressure is basically either it's a greenfield area, or you have to consider, again, a permitted well where that pressure front is there already. And it would limit your application. So if you were going into a greenfield area, no other injectors in that space, and let's say that 2 miles, then you have to understand the porosity permeabilities of your injection formation and the natural pressures you'll expect to see. But if you're going into an area and you want to permit next to an active and permitted well, then yourself that you are taking a lot lower pressure and volume than you would in a greenfield area. And those things already guide decisions. They're being made by operators to look for areas where it is more of a greenfield than in an area of competition, because through this permitting process, we get back to the fracture gradient requirement that you cannot inject above 90% of fracture gradient, and that is an additive from another injector in the area. If it's already there, you have to consider that. So yes, it's contemplated in the permitting, but it's not as specific as what we're using to describe this.
Do you think that'd be important to have in the rule to state that existing instruments would not be affected by Class 6?
I think in my mind, you would run into unintended consequences of that, trying to choose the right language based upon things that are really tied more to exactly what this language is focused on, and that's the subsurface pressures, fracture pressure gradients, and all of those things. So I actually wouldn't recommend it because it's built into the permitting process.
So let's say there was, CO2 and SWD were injecting into the same zone, and there was a induced seismic event. How would they figure out who is responsible and who would be responsible for damages to the other well?
So what I would say, and the reason I'm giving this answer is because there's such a similarity to Class 2 AGIs and SWDs, and it's already, occurring throughout New Mexico where they're injection in the same zone. It's the same intended zone for injection. And so what I'm aware of, and Justin can speak to this more thoroughly, is that if there was a seismic event, again, there would be a triangulation, there would be an identified characterization of the event, and then there would be a OCD. Number one, the operators have to report. OCD immediately begins to try to assess where that came from, what was the influencer, and make corrective actions at that point. I don't know, Justin, you want to add?
I mean, so if this scenario took place and each one of these wells were located within a zone that required them to shut in or do 50% reduction, and let's just say that are you saying like they communicated with each other, or one well caused the?
Yeah, let's say I guess, for example, let's say the CO2 well caused the induced seismic, or caused the injection pressures for both wells need to reduce. Who would cover those damages?
So,
if I may, I apologize for interjecting again, but damages are a civil remedy, and they are not within the purview of the Energy, Minerals, and Natural Resources Department, or OCD specifically, any of its divisions. So this is a legal argument. Mr. Wrinkle and none of the witnesses can testify to this. The issue which I would distinguish here is that the division will be responsible for determining whether there are any permit violations, whether there are any corrective actions necessary, whether there's an area review or a cessation requirement necessary, if there are any civil penalties that are appropriate, if there's any need to, in extraordinary circumstances, refer the violation for criminal, potential criminal. That's never happened yet, but it's possible. And the civil damages are another matter entirely. They will not be addressed in this rule or in any OCD rule.
Okay, I guess so. Kind of talking about money makes me want to move to financial assurances next, if that's okay. So, the New Mexico State Land Office wants to ensure that a company or operator or person has sufficient financial assurance prior to the operation of wells, because we don't want the taxpayers to be left with any burden of financial assurance not being accurate. So on that, can you please remind me what is covered under the financial assurance? Is it just the well bore? Is it surface damages? Is it mineral damages, endangerment to USDWs? Does the financial assurance cover all of those possibilities?
Well, I'll begin by pointing you to the proposed rule at Exhibit 3, beginning at page 8, under financial responsibility, and then under Part 1B, the qualifying instruments must be sufficient to cover the cost of corrective action, and that term refers to addressing artificial penetrations and abandoned wells within the area of review. Injection well plugging, which is the plugging of the injection well or wells. Post-injection site care and site closure is the monitoring that happens after, and then the final is emergency and remedial response. And so I think that may partially address your question. I think that, are you asking really about when it comes to emergency and remedial response, what kind of emergencies and like what are we impacting?
Yeah, or let's say, I mean, it was mentioned earlier that theoretically a CO2 well could leak into a reservoir that has minerals that are being affected. Would this bond cover that that damage?
Go ahead.
I think, and Jesse can correct me if I'm wrong, but I think if that took place, then that would also fall under the civil matter of damages.
Yeah, do you mind repeating?
So as written, I do not believe that bonding covers any mineral degradation if the well communicates with a producing reservoir.
Yeah, I apologize. I missed something here. Again, as I said earlier, damages, civil damages would be outside the scope of the rule.
What about like lost royalties to the state? Would that be?
OCD does not regulate royalties.
And I guess this was kind of another part of the question. So does, will the bond cover any potential environmental hazards that could occur?
Agree? Yeah. Okay.
Under Part C of the same section on page 9, it says the financial responsibility instruments must be sufficient to address endangerment of underground sources of drinking water. Other than that, the Part B4 references the emergency and remedial response activities. And in practice, it would cover addressing any issues that are identified in the project's emergency and remedial response plan.
Okay. So, do you think it would be good to have the bond amount increase every 5 years or so based on a consumer price index?
One second. I think that there is a clause in here that demonstrates that they have to account for inflation.
There's Part E2.
You want to read?
Well, this is not
Where is it? E2?
Yeah, I can if you want.
Yeah, I mean, just read it.
I can read E2 in this section. The owner or operator must provide any updated information related to their financial responsibility instruments on an annual basis, and if there are any changes, the director must evaluate within a reasonable time frame the financial responsibility demonstration to confirm that the instruments used remain adequate for use. I'm not sure if that's comprehensive of everything about that issue in here, but I believe at least partially covers it.
Let's see. Sorry, I'm just looking over my notes. So I believe that the bond, the cost estimate is done by a third party to verify. Is that correct?
That's correct.
Okay.
It's
And,
under, yeah, sorry, go ahead.
oh, no, go ahead.
If you want, I could point to where that is, but it sounds like you already have it.
Yeah, I think I do. Let's see.
Do you want to point that out, or do you want me to? Sure. Yeah.
On page 10, if you look at 3, Part B, during the active life of the geologic sequestration project, the owner or operator must adjust the cost estimate for inflation within 60 days prior to the anniversary date of the establishment of the financial instruments used to comply with paragraph 1 of this subsection. and provide this adjustment to the director.
Okay, thank you. And on page 11, number 6, it says the director must approve the use and length of pay-in periods for trust funds or escrow amounts. Does that mean that the full financial assurance will be accounted for before operating and drilling and permitting, or maybe not permitting, but drilling a Class 6?
I think this falls under where I mentioned earlier. I know that there's a process when you're reviewing the trust fund, self-insurance, and that does fall under the OCD legal rather than the Admin Compliance Bureau for normal bonds.
Okay. And the bond is kept on file for the entire post injection site closure period, right? Which is that a max of 50 years? I know it could be less if deemed by the director, but.
I can answer that one part of your question about the post-injection site care period. It's a default of 50 years. They can try to demonstrate that their project-specific assumption is shorter than that, but in practice, it has to do with when they can demonstrate non-endangerment. So there are instances where it could be larger than 50 years or shorter than 50 years.
So you can't ask for more than 50 years? Or the director could ask for more than 50 years?
I don't believe that is envisioned in the Class 6 program, that the default would be greater than 50 years. But during this phase of the project, when they actually are monitoring, if they can't show non-endangerment at 50 years, they would be required to continue longer than 50 years.
Okay.
And to answer your question about the PISC, or post-injection site care, on page 9, on 3, under the requirements of the financial instruments, it says it must also cover the post-injection site care and site closure.
Okay, thank you.
Okay.
So what happens if something happens right after the post, let's say it's 50 years, what happens if there's a danger or damage, 51 years, who's responsible for paying for those damages if the bond is no longer on file?
Go ahead.
Yeah. So if once they meet excuse me, what was the name of
Non-endangerment demonstration.
Non-endangerment demonstration, which is a very intense bar to pass. If that was to happen, then it would fall on the state, just like a well that does not have a bond.
If I may, this is outside the scope of the rule, I may refer the commission to 74-14, that is the Geological Carbon Storage Stewardship Fund. There's a fund created for that post-endangerment finding that is beyond the scope of this permitting and non-endangerment, so we haven't addressed it. But that is where that authority in that fund lies.
Okay, thank you. That was going to be my next question, to see if there's something similar to the Oil and Gas Reclamation Fund, which it sounds like there is. Would the State Land Office be able to call on financial assurance if there was no non-compliance on state lands?
I don't believe I'm qualified to answer that.
Okay. Let's see. Sorry, I have one more question about this. I'm trying to figure out where it is in the rule so I can. maybe someone can help me if they know where it is faster. I'm looking for reasons that a director can ask for a higher bond.
Are you referring to page 9? It would be E3I. The director may disapprove the use.
I'm sorry about this. Let's see. I guess I could just kind of ask it in a more general question. Can the director ask for higher bonds due to compliance issues?
I think that on page 9 of Exhibit 3, E3 is the one place where it says the director may disapprove the use of a financial instrument if he or she determines that it's not sufficient to meet requirements of this section. I'm not entirely sure without a little bit more review if it's due to compliance reasons.
Would that be something, if it's not in here, would that be something that might be included into the rule to raise bonds for non-compliance issues?
Being it a compliance kind of legal issue, I don't think I have the expertise to answer that. That would probably be left to an attorney to decide if that was valid justification for raising FA.
And so I know there's some discussion about permit transfer, and I was just wondering if you could kind of explain what that process would look like and the review process of the operator that will be getting the permit.
Yeah, if somebody could help me find that. I know that that is an area where we were more stringent than the EPA,
Okay.
where automatic transfers are not allowed
Yeah.
in this draft rule.
So I know it's in Exhibit 2. There's two parts, I think, where it talks about this, is in 11 and 12.
Page 10.
Yeah, page 10G is one part where they discuss transfers.
Okay, just reading through this here. It says only if the permit has been modified or revoked and reissued under subsection H 1915-4211, or a minor modification made under subsection J 1915-4211 to identify the new permittee, incorporate such other requirements as may be necessary under the Safe Water Drinking Act.
And will the company who's getting the permit transferred to them, would they need to go through the same stringency review of financial assurances as the original permittee?
Yes, that's been the normal case in other classes and with oil and gas wells.
And so they would have to get a bond
Yes.
in their name? Okay. Okay, let's see. Okay, I kind of want to talk a little bit about the rulemaking outreach now. Ms. Rainey, did the OCD reach out to the BLM for comment? They seem like they're important stakeholders in this process.
The OCD communicated with the BLM directly.
Okay. Did the OCD reach out to the BLM? Mr. Winkle, I don't know if you'd be the best person.
In this particular context, during the development of the rule, we as a group, along with contractors, contacted the BLM when Ms. Rainey did.
Did they provide any feedback to the rule?
It was I don't have this in writing, it was my understanding they don't comment directly on rulemaking process.
Okay. And was there outreach to the Energy Conservation and Management Division about new geothermal rules and geothermal permitting?
In communication with them on geothermal wells in general, because it's related to what PWRC works on, making them aware of this process.
But they weren't given an opportunity to comment, were they?
The public comment period was made available to everyone and posted publicly.
Okay. And I know the State Land Office met with Ms. Rainey and Mr. Eels in late October, like you stated. And in that discussion, we talked about exhibits 1, 2, and 3, but there was also another area, Reserve 4, and that was shared at the beginning of this rulemaking process for people to look through. And that was an area that covered a lot of mineral rights and unitization and other concerns. And I was wondering why that was not included in this rulemaking.
If I may, the decision to move forward with the rulemaking package was a decision that was made in consultation between MNERD leadership and council. This technical team is here to support the rulemaking package before the commission. As I said earlier, this is an issue, this is a topic, there is draft language, and it is something that we are actively working on. It is a distinct subject matter. It's a distinct factual record necessary to support it. There are distinct legal arguments and principles. It is not before the commission, respectfully.
Okay. And so I know you said yesterday that the OCD was supposed to reach out to us reach out to the State Land Office with more commentary on our concerns. And Mr. Winkle, can you confirm that you or someone from the OCD got back to the State Land Office regarding our comments on the rule?
So my participation in this project, the most that I know about the comments were I was consulted on them, and then we did turn in the FAQ, but I cannot confirm that anybody that I know of did get back to the SLO. Maybe some of